Can I just say thank you for having an opportunity to have a normal conversation? That's wonderful.
All right, so we're going to kick off here, and then if you're okay with it, I'm going to do just a couple of questions, and then I would like to pass the mic around the audience and put you on the spot, because that's always comfortable for people.
I love that.
All right, so where I wanted to start, and this is a personal question that I drafted. So we all know what COVID did to our lives and our families and our freedoms beginning in 2020, and we know that it was a single woman on Wisconsin DHS that had the power to shut us down and take our freedoms away and say, you cannot go out, your children cannot go to school, you do not have the right to move freely, your inherent right to move freely. So at that time, obviously, she's no longer with the state, thankfully, Andrea Palm, and you and some other justices at the time took her to court. How did that all play out? Tell us about the end result and what we're facing in the future with DHS.
Yeah, so we had something to say about that idea of shutting down the entire state by a single order from an unelected bureaucrat. So I was actually intrigued by how this came to the court. So the Wisconsin legislature looked at what she was doing and they said, hey, wait a minute, aren't we supposed to be the ones that make the law? And so they came to the court and said, could you tell them that we're the ones that are supposed to make the law? And so we looked at that, and here's how it came about. You might remember this. So COVID came along, and then pretty quickly, the Safer at Home order started. So Secretary Palm walks into her Madison office one day, sits down at her keyboard and says, you know what? I know how to run the state better than the legislature. And so she tapped out a brand new law, and then when she's done, she printed it off, held it up for the state to see, and said, behold my law, which I just made today all by myself. Pretty proud of it. And she said, just so you know that this is a law and not a suggestion, look down at the bottom where it says that you can be criminally prosecuted if you disobey it. So that's what came before the Supreme Court. And we looked at that and we said, all right, so is this a lawful order or not? And the opinion of the court, written by Justice Pat Rogensack, said this is an unlawful order because it did not go through the rulemaking process and therefore is unlawful. And that's true. It didn't go through the rulemaking processes, and as a consequence, it was unlawful for that reason. But that really just scratched the surface of the problem. So Justice Rebecca Bradley and I, we looked at it and we said, wait a minute, we recognize a law when we see it. And so we did some research and looking for the essential attributes of what a law is, and then we checked with your Constitution, the Wisconsin Constitution that belongs to you. And what we saw that you told us, the lawmaking power belongs in the legislature, not the executive branch. And so our responsibility as the court is to make sure that anything that we enforce is something that is consistent with the Constitution. And we looked at the order and we thought, well, here's something that bears all the attributes of a law, but it wasn't made in the legislature. So do we, as a court, have the authority to enforce that? And we concluded, Justice Rebecca Bradley and I did, that we didn't have the authority to enforce that because it was unconstitutional, because the executive branch was stealing the authority that belongs to the legislature and using it there. Now, why is this important? Well, we have a legislature for a reason, and it's the most populated branch of government for a reason. We have all those assemblymen and all of those senators there drawn from all over the state, from all different backgrounds, all different education, experience, and wisdom, and we get them all together so they can figure out what will be the good laws that will lead to human flourishing. We don't want to leave that up to someone who's not representative. We don't want to leave that up to a single individual. When our laws come, we want to know that they've been approved by representatives all over the state, and that's why that's important.
Excellent. Thank you so much. That's amazing. So let's talk about what it means to be a Supreme Court justice. I think a lot of people believe, and I didn't know anything about legislative process at all until I got involved in health freedom and vaccine choice. So your job is not to write law as a Supreme Court justice. It is to follow the Constitution and to enact the law as it stands. Explain to us what it would mean to have you there over Janet. How would you be able to, again, we're here for vaccine choice, parental rights, and health freedom, and those are massively under attack, unfortunately, by the left. And we want to maintain our rights as parents to have an education, to be able to say no, our child doesn't want, or we don't want them to have a vaccine.
Yeah.
We don't want our kids to miss out on a year of school and have all of their mental health just absolutely fall apart. So what does that mean? Because we know that you are not doing your job based on feelings. And we hear a lot about this, that, opinion and your opinion, and opinions don't matter when it's coming to enforcing our Constitution. So tell me what it means as an individual, as a civilian, having you on the Supreme Court. How are you going to protect my rights? What does the Constitution say about choice in our state?
That's good. All right, so one of the things I forgot to ask you before we started is, how much time are we spending together here this afternoon?
I was told till 3:30, but I'll keep you all day.
All right,
You have
so...
Walworth County.
No, I get it. So 3:30 a.m., I can do that.
Yes.
That's fine. Don't worry. So I'll try to keep this down to, say, 1 credit of law school education in this answer. So there's a whole lot that goes behind this. But the primary difference, I think, between having my opponent on the Supreme Court and me is I understand the responsibility of a Supreme Court justice is to follow the law, not to make it. Now, I remember when I got into the race, and my opponent had something to say about that when I got in. She says, why, he's a radical with views of the law that are far outside the mainstream. And I literally laughed when I heard that, because I was thinking, my view of the law is that the courts should follow it. I don't know what would be radical or outside the mainstream about that. That's our job. So let me start with this. It goes back to the beginning. So 175 years ago, we became a state with the adoption of the 1848 Constitution. And in that, the people of Wisconsin created it at that time, and they've maintained it ever since. And that document is there to tell all of us in public office what you have commanded us to do, right? And there's a reason for that. So all of the authority to create and maintain governments in the state of Wisconsin belongs to who?
Us.
Yeah, we the people, right? It even says so in the very first part of our Constitution, the preamble. We the people of Wisconsin, grateful to Almighty God for our freedoms, to secure its liberty, its blessings, to form a more perfect government, to ensure domestic tranquility and promote the general welfare, do establish this Constitution. That's a statement of ownership. That's we, the people of Wisconsin, saying, listen up, everyone. We're creating a state government here, and it belongs to us, we, the people. So, all right, so how does it come to be that those of us in state government are exercising authority that belongs to you? Well, you didn't give it away, you didn't sell it, you didn't alienate it in any other way, you simply loaned it to us. So you say, here's our Constitution, this is our loan of authority to you, pay attention to what we've told you to do. Because one of the most important aspects of that loan is that you did not loan it in one undifferentiated mass, you divided it up into 3 sections: legislative, executive, and judicial. And so as I was on the Supreme Court, I looked at Article 7 of the Wisconsin Constitution, that addresses the judiciary, and there I see the people of Wisconsin looked at us and said, we have one job for you, just one. Please pay attention, do it well, but it is just this one job. Use the existing law to decide the cases that come before you. And they went on to say, we're not interested in whether you think the law is wise or efficacious or anything like that. We have an entirely different branch of government to address those questions. It's called the legislature. So you just do this one thing, and then if we think the law needs to change, we'll go talk to the legislature about it. But you and the judiciary just do that one thing. So I understood every single time I walked into the Supreme Court chambers that the authority I would use that day did not belong to me. And it didn't even belong to the office. It belonged to you. And so every case I analyzed, every opinion that I wrote, started with the premise I've been asked to do one thing, and I took an oath. I put my hand on the Bible, and I swore to God I would be faithful to what you commanded me to do. And that's what I did every single day. Now that's me. Now my opponent, she has an entirely different way of looking at the law, the court, and you. So she subscribes to a judicial philosophy called living constitutionalism. And the idea there is societies change over time and laws don't. And so those jurists look at the law and say, well, that law becomes out of date after a while. And somebody needs to bring it up into the modern age. Our Constitution was written in 1848. Now this is 2023. It's an entirely different society today. How could it possibly be that a 175-year-old document could be relevant today? And so they tell all of you, don't you worry about it. We got it. We see your document. But it's okay. We can take care of this. We can make sure that it is updated to today's standards. And what that really is a statement of disdain for you. Because just because that document was written 175 years ago does not mean it needs to stay the way it was written. Same thing with the United States Constitution, right? So the United States Constitution, Article 5, contains an amendment process. So if we, the people of the United States, decide that that document needs to be updated, there's a way of doing it. And we've done it 27 times, so we know how to do it. And in the Wisconsin Constitution, it's Article 12 that controls the amendment process. And we've amended the Wisconsin Constitution a bunch of times. You know, when I say we, I mean the people of Wisconsin. Now, I've looked at both of those provisions, controlling the amendment of those documents, both the United States Constitution and the Wisconsin Constitution, and I see there that the people have given us no authority in the judiciary to change even a single word in those documents. You've reserved that authority to yourselves in conversation with your legislatures. And so people like me, I look at that and say, well, I will follow this document as the people of Wisconsin and as the people of the United States are maintaining it. And if they believe it needs to be changed, they'll change it. And then I'll apply that change. And that's your authority to do. It's certainly not a jurist's authority. But my opponent looks at it and says, oh, no, I see the amendment process, but it's bulky and it's kind of hard to get something changed. And so without authorization or anyone's permission whatsoever, we will steal that authority from you, the people, and we'll use that ourselves. And as they do that, understand what they're saying to you. They're saying that they're smarter than you are. They're more aware of what the law needs to be. They are looking down their noses and condescending to we, the people. Now, why is this a problem? Well, it's a problem because we, the people, are the bosses. And those of us in the judiciary, we're the servants. And one of the things I've learned a long, long time ago is that servants don't tell bosses what to do. You listen carefully and you do as you're commanded. So that's the difference between me and my opponent. My years of service on the Supreme Court consisted of me listening to you, to what you've commanded us to do, and then I did that in every single case. If my opponent gets on the court, it'll be her commanding you and telling you what your laws can and cannot be, what your liberties can and cannot be. There won't be any listening.
Great answer.
All right.
Thank you very, very much. All right, I have one last question, and then I really want to give this over to everybody here and give them a chance, because I don't know how much audience interaction you get a lot of time. You're usually kind of hanging out.
Not nearly enough.
Yeah, great. So we're talking about partisanship and what it kind of looks like. Unfortunately, we have to divide on the right and the left. And we know that on the right side, we believe more in parental rights. We believe in individualism. We believe, that we as individuals are going to live our best lives and contribute to the betterment of society. Where unfortunately on the other side, there's more of a herd mentality, and you do it for the herd and the collective good, and you give up your rights to self because you're doing what's best for the herd regardless of the outcome. Where are we at with that constitutionally in our state? Like, where are we at with these mandates and potentials for that kind of stuff? How can we, I know this has been a question on a lot of our minds for a long time, where are the rights of the individual in our state right now? Because I know, as someone, and I've gotten to meet you a few times over the years, which has been great, that you help maintain those through like the lawsuit and that kind of a thing in our Constitution. What would it mean if you didn't get into the Supreme Court? Individual?
All right, so now I thought we were going to do some questions from the audience, and this is the question that takes us to 3 in the morning. All right, so the question here is whether I go back 240 years or 600, and so we'll take the short version.
That sounds good.
All right, so this is what it looks like. This goes to the very essence of what it means to have a government and what its responsibilities and obligations are, and what things it can legitimately do. So let's go back to 1776, and we declared our independence from the world's greatest superpower at that time. And why did we do that? Why did we do that? We looked at the government and King George, and we said, wait just a second here, you are infringing on our liberties. We came here to live as a free people, and we demand the rights of Englishmen. And there you are, King George, and you're violating them, and you're taking away our liberties. You are acting as a tyrant and dictating to us the way that we can live our lives. So if you look at the Declaration of Independence, it's one of the most remarkable documents ever written in the governmental realm, because the authors went through the list. It wasn't just a generalized, I don't like this government anymore, and we're going to throw it over. It was, we're going to list out all the offenses that justify us in doing this, because they understood that a revolution should not be taken for light and transient reasons, but then it must be fundamental, going to the very essence of what it means to live together in society. And so they listed out, and every single one of them was an imposition on their liberties. And they said, you are acting tyrannically, and we're going to throw off that yoke. And you probably remember how that document begins. We hold these truths to be self-evident, that we are endowed by our Creator with certain unalienable rights, that amongst these are life, liberty, the pursuit of happiness. To secure those rights, governments are instituted amongst men, deriving their just powers from the consent of the governed. That, in a nutshell, sums up close to 800 years of Western political development in lining out the proper relationship between government and those who are governed. And the idea was this: we want to live in freedom and in liberty. It's going to be an ordered society, because it has to be if we're going to live amongst each other. But the presumption is one of liberty. You choose how best to live your life. You make the decisions that will promote human flourishing in your life and in your family's lives and in your community's life. And these are authorities that are left to you. Now, we do have to have a government so we can take care that laws are faithfully executed, and so that we can live together in society in peace and with the prospect of prosperity. So the question then becomes, how do you do that? How do you construct a government that will be able to keep the peace and yet still allow people to live in liberty and make their own decisions for their own lives? Well, we figured this out in two different ways. So you guys know we've got the United States Constitution, but then each state has its own constitution, and they accomplish two very different objectives. So with the United States Constitution, that came after the establishment of the states, right? And if you'll recall your history, we started out with the Articles of the Confederation after we won the Revolutionary War, and that didn't work out so well. But we had the 13 states, and we're trying to figure out how do we live together as states and maintain that essential liberty. And the first attempt at that was the Articles of Confederation. It just didn't work. So when we constructed the United States Constitution, we had in mind we've got to give it enough power to accomplish its objectives, but we have to give the power in a way that is protecting the liberties that we retain to ourselves. So the first step in that was to recognize that the federal government would be one of limited and enumerated powers. Basically, the idea is that unless we affirmatively granted the federal government authority to do something, it wouldn't have the authority to do anything. You had to affirmatively give it to it in each little dollop of power. And so you look at Article 1, Section 8, and there you will find the list of things the federal government is authorized to do. And it can't do anything else. And so that's one way of constructing a constitution. Those are the things that you can do and nothing else. If it's not listed, you can't do it. So that's a constitution referred to as one of limited and enumerated powers. So your freedoms are protected by the fact that they can't do anything that you haven't told it could affirmatively do. Now, then you get to the state constitutions. Now, state constitutions are different because they say, all right, state governments have the power to do all things that states can legitimately do. But then the question comes up, what can states legitimately do? And here's where we hearken back to the Declaration of Independence. And we took really the operative part of that and we made that a part of our Constitution. So you won't see this in the United States Constitution because you didn't need to, because it's a limited and enumerated powers form of Constitution. But when you get to a plenary Constitution like ours, where the government has the authority to do all things that governments can legitimately do, you have to put some limits on that. You have to say, okay, these are the areas of legitimate action. And so Article 1, Section 1 of our Constitution, I'll read it off to you, and I think you'll recognize where it came from. So it starts like this. We are all born equally free and independent and have certain inherent rights. Amongst these are life, liberty, the pursuit of happiness. Governments are instituted to protect those rights, deriving their just powers from the consent of the governed. It's the very beginning part of the Declaration of Independence. Here we moved it into the Constitution so that those in state office would understand the nature of their authority and the ends to which is to be exercised. So basically, this is law and order and protecting rights. That's why state government exists. It's not there to be tyrannical. It's not there to dictate to us every aspect of how we live our lives. It is there to protect the rights to life, liberty, and the pursuit of happiness. That's why it exists. That's the obligation of government. And then we go on and we identify certain specific rights we want to make sure that government is really sure to take care of. And then we describe its powers in a way that's similar to the way that we do in the United States Constitution. But that's the different kinds of constitutions and the different kinds of provisions you need to have in them so that the government can do its job of protecting our rights, but not going so far as to impinge on our liberties. And so when we get to questions like parents' rights and medical freedom, this is the analysis that we do. So we start out with which constitution is covering this question. So the United States Constitution doesn't have anything to say about this. So we say, okay, that one's off the table. So now we get to the state constitution, plenary authority, all things that a legitimate government can do. And then with that objective of protecting rights. Now, legislature, it's your job to pass laws that will promote human flourishing within that context of protecting rights. So now, of course, and we've talked about this before, I can't tell you how we would answer any particular question on the court, so I can't get to the final answer in this. But I can tell you the analytical construct, and that's how it would work. So anything that the government would propose to do, whether in the legislature or in the executive branch, we'd look at that and say, all right, is there a rational relationship between that and what the legitimate powers of government are? And of course, the place to start with that is Article 1, Section 1, telling us what governments are legitimately to do. So that's the analytical construct that you go through, but the ultimate result of it is this, in a general concept, is there is a presumption for liberty, a presumption for freedom, and the government has to prove it has the authority to do what it's proposing to do.
Excellent, thank you. All right, I'm going to hop down and start walking around and let people ask some questions. So, Karen, I know you wanted to ask one like the second we got here, so I'm coming for you first if you want to answer your question, or ask your question. Excuse me, I don't even know how we're doing on time. Okay, down here.
It's still light out. We got plenty of time.
Okay, thank you very much. We have 30 minutes.
All right, 30 minutes.
All right.
I was trying to figure out how to frame this question, but we've all seen the flyers from Janet. And I was wondering if you could speak to us about the third thing on our list about the rights of a woman. You know, if she happened to have a medical condition and there was a choice to be made, can you speak some truth into what the Constitution says about that? Does that make sense?
It does make sense. Now, here's the limitations I have on me as a candidate, and hopefully soon back on the Supreme Court as one of your justices. So we can't talk about how we would resolve any particular question that would come before the court, and there's a good reason for it, though. So I know how it sounds when someone says, "Oh, I'm sorry, I can't tell you how we would decide that." It sounds like a dodge, right? I just don't want to say. But this is part and parcel of what it means to be a jurist. So as people bring their lawsuits to us, we have twin obligations. One, to follow the law punctiliously as it's written, not as we wish it to be, but as it's actually written. And the reason for that is because we want people in Wisconsin to be confident their cases are being decided according to law and not according to the jurist's personal political views. Right? So one of the ways that we ensure they have that confidence is we don't talk about how we would resolve specific issues before it comes to the court. Because the last thing you want, I mean, think of it this way. Say you've got a lawsuit, you're the plaintiff. You walk into a courtroom, it's your day to be heard on your case. And the judge is there and he's going to be making the decision. And you walk in and you see the judge on the bench and you think, oh no, I just saw him out yesterday and he was publicly talking about his political views and how he would resolve specific cases. And he was talking about the law that I'm relying on for my case. And he was talking about how much he doesn't like it. Now, am I going to have confidence that that judge is going to dispassionately resolve that case according to law? Or would people start thinking, wait a minute, maybe he's going to be incorporating his personal views and his personal politics and how to resolve that case? And so that's one of the reasons why we don't talk about specific issues before it comes before us in a case, because our project, and it's one that needs a lot of work, frankly, these days. Our project is to restore people's confidence in the court that it is not a political institution, but instead a legal institution. So all the political questions, how we should resolve different issues extant in the community, those get answered in the legislature. And once they answer them, the answer comes in the form of a law. And we in the judiciary, our only authority is to apply laws. So we don't go back behind the laws and start remaking the calculations that went into the creation of that law. We simply take what the legislature did that comes before us. And so one of our obligations is to set aside we would, but wait until the case comes to us and then faithfully apply without regard to personal politics. Major differences between me and my opponent. You won't find me anywhere in the talking about my personal politics because they're just not relevant to the work of the court. I mean, it would be just as relevant if I started talking about who the Packers' next quarterback ought to be, right? Say, okay, here's what you really need to know about me as a judicial candidate. This is who I think the next quarterback for the Packers got to be. And therefore, won't you support me in my campaign? And we'd look at that and we would laugh. Well, that's ludicrous. Well, we should be laughing when a judicial candidate comes to us and says, well, let me talk about my political views. This is what you need to know about me, my political views. We should laugh at that because it's completely irrelevant to the work of the court. Now, if you want to go run for the legislature where political questions are resolved, oh, then talk about your politics all day long, right? So now that was all a lot of throat clearing. Now to the answer to your question. So I can't say how I would resolve it. I can say how I would approach it and the methodology that I would use in answering the question. So again, I start with constitutional provisions, and then all the legislature does, all the law passes, consistent with the Constitution. And if there's a discrepancy there, if the legislature does something the Constitution says you can't do, then we pick the higher law to follow, right? And the higher law is the Constitution. So if there's a conflict between a statute and the Constitution, we look at the statute and we say, well, that's unconstitutional. We follow the Constitution instead. Now, oftentimes that's known as striking down a law, right, as unconstitutional. Oddly enough, we actually never strike anything down. All we say is we can't apply that law in the Constitution simultaneously without conflicting with each other. And so we go with the more the Constitution. But just like the 1849 statute on abortion is still on the books. Now, it hasn't been applied for decades because of the United States Supreme Court's decision in Roe v. Wade. All right, so that was overturned this past summer. And so now we go back, and what does the law look like? Well, as it turns out, that statute's still there. And so the question, as that comes before the court, and it almost certainly will be in the way, unless I'm mistaken, I think the first posture that it'll come to the Supreme Court in will be this, because this is a lawsuit that Attorney General Call started just this past summer. And in that lawsuit, he says, well, there's a 1985 law that addresses abortion, and he says it's in conflict with the 1849 statute that addresses abortion. And he says, so the 1985 statute impliedly repealed the earlier statute. So that's the way the case was structured the last time I looked at it. I haven't reviewed the pleadings recently. I just took a look at them when they were originally filed, and that's the argument that was being made. So unless the pleadings have changed, that would be what comes before the Supreme Court. Does the later law impliedly repeal the earlier law? And the way we resolve that is we look at the provisions and say, well, can you apply the later statute without being in violation of the earlier statute? And if you can, there's no repeal by implication. If you can't, then the earlier statute is repealed to the extent the later statute without conflicting with the former. So that's the way, and this is one of the other interesting things about the way my opponent talks about this. She talks about it in a distinctly political way. So she suggests that the question that will come before the court will be, shall there or shall there not be abortion in the state of Wisconsin? Shall there or shall there not be exceptions to an abortion ban in Wisconsin? But that's not how questions come to us. We have legal questions come to us. We don't have policy questions come to us. And so, like in this case, it's really a matter of statutory construction. And in that sense, it's really no different from any other statutory question that we ever address. What do the statutes say about this subject? Statutes on what? Now, it could be that someday someone will say, well, I see that 1849 statute and I think it's unconstitutional and that it should be struck down entirely, and maybe somebody will bring a lawsuit like that and it'll come up. But again, the question won't be, shall there or shall there not be abortion? The question will be, does that statute conflict with a provision in the Constitution? And if it does, then to the extent the conflict exists, you prioritize the Constitution over the statute. If it doesn't conflict, it's not for us to decide whether that 1849 statute is a wise or not, or whether it's an effective law or not. Our job, as the people of Wisconsin have told us through their Constitution, is to simply solve the case, and that it's not inconsistent with the Constitution, and then be done with it. And the people of Wisconsin say, if we want to change it, we'll go talk to the legislature. So that's kind of a roundabout way. Is that all right? Does that get it? Okay, great.
Hi there.
Hi.
I'm going to put you on the spot for a minute.
I feel like I'm already there.
I was part of the Republican Women of Dade County, and we worked really hard to get Hagedorn elected. And then we feel like he turned on us. So my question to you is, do you believe Hagedorn is a true conservative?
All right, so that's a great question. And I've talked about this a little bit in the campaign so far. Here's what I think. If you asked Brian today, are you a constitutional conservative? I think he'd tell you yes. And I think he would believe that. As I've watched the opinions and read the opinions that he's written, here's what I've come to. And I've told him this personally, so this is not speaking out of school. But I think he has an incomplete understanding of the separation of powers. And so there's a couple of cases I think that illustrate that. One is the Palm decision. So of course that was the safer at home order. So that comes to us, is it a lawful order or not? And as I mentioned, Justice Rebecca Bradley and I looked at it and we said, no, this is a separation of powers problem. The executive was stealing the legislature's authority to make law. Now, the thing I didn't mention was that was a 4-3 decision. So Brian was in the dissent. So he looked at that and he said, I see no problem with that. And in fact, he wrote separately to criticize Rebecca Bradley and I for our constitutional analysis. And he says, there's no constitutional prohibition against the executive writing out that order all by herself without any legislature and imposing it on the state of Wisconsin. He says, I see no violation there. All right, so we had a little bit of back and forth in that case, and it's all in writing, so you can see that. I didn't leave the court, and then the following year, the same question comes back to the court, but this time at a local level. So the Dane County public health official looked at Secretary Palm's order, the one that we struck down, and she said, oh, I like that. We want some of that in Dane County. And so she essentially copied it, instituted that in Dane County as their public health order. Comes back to the court. The question is, again, is it unconstitutional? Did you use authority that did not belong to you? I wasn't there again, but the other way around. And in that case, Brian was in the majority saying that order is just fine. Even though we had said in the prior case, and I had said it violated the separation of powers by stealing legislative authority. So the separation of powers applies at the local level too, at the county level. So the county is the one that is supposed to be making county level law. not a public health officer. Public health officer is in the executive branch of the county government. So, and then wrote separately and specifically to say, well, you know, the separation of powers, you know, we don't really have a whole lot of information about how that's actually supposed to work. And so, you know, I just don't see anything here that says that executive branch agency can't make the law. And I look at that and I say, well, okay. So when we wrote our 1848 Constitution, we did that the powers and all of the scholarship that went into just how that separation of powers is supposed to work. And Brian just shoves that to the side and says, well, we're starting over in a clean slate here in Wisconsin. And so unless there's something else out there telling me what the separation of powers means, then I'm just not going to apply it. So that's the problem that I have with Brian Hagedorn's reasoning, right? And I was asked about this in a interview show the other day, and they said, well, how come you and Brian, you both call yourselves constitutional conservatives, and yet you criticize him for results in his opinions? And I said, whoa, I don't criticize anyone for results. I criticize for reasoning. Reasoning is the thing that is key to jurists. We don't pick winning sides. We move from the law, that's the premises, and to reason our way down to the conclusion. And in some ways, the conclusion is kind of beside the point. It's the reasoning that we use to get there. And we should be driven by what the law says rather than what we want the conclusion to be. I don't know if Brian personally wanted the conclusion to be that way or not, but as I read his reasoning, I see problems with that. I see that he's not following the separation of powers that's written into the very heart of our Wisconsin Constitution. So, so would he consider himself a constitutional conservative? Yes. Is it an incompletely formed jurisprudence? I think so.
Time check, we've got about 20 minutes left. So
That's up to you. I got all the time in the world.
okay.
Hi, Justice Kelly. Nice
Hi.
to see you twice in 24 hours. Question. Ben Franklin said something along the lines that those who want to give up freedom for the sake of safety deserve neither freedom nor safety. In terms of COVID measures, how do you explain to a friend that the Constitution assures people life, liberty, and the pursuit of happiness, and that that person should maybe value freedom over safety in terms of what the COVID measures?
Yeah, two ways, I think. One, get a video of this and show that, and that might show, I mean, the explanation I went through about the different objectives of the federal and state constitutions and all that, that might actually help clear that up a little bit. But as far as the importance of liberty, I mean, think about this. Think about what happened back in 1776. There were a bunch of people who decided liberty is so central to who we are not willing to live without it. And they took up arms and they went against the world's one superpower at the time. They said, we would rather die than live without our freedoms. Well, I think that's part of maybe something that we've lost in the insistence that we live in liberty, that we decide for ourselves how to order our affairs, how to order our lives. And there is an awful lot of virtue in saying this is our right. It's our birthright, right? So when the Declaration of Independence talks about those inalienable rights, how does it talk about them? Does it talk about them as I've heard so many living constitutionals talk about it, as we granted each other rights? So is that what it said? No. It says we are endowed by our Creator with these rights. We don't ask for these rights from someone else. They are ours by nature of the fact that we're created beings and we bear the image of God. That's why we have these rights. And I think the question we have to ask ourselves is, how much do we value that, right? And do we have enough respect for our fellow human beings to recognize the imago Dei in them and say, just like me, you've got your inherent rights as well. Your unalienable, God-created rights. And that should order everything about how you interact with others. It is with mutual respect, understanding that you are no greater nor no lesser than any other person. We come to each other, we encounter each other as equals, fundamentally as equals, right? Equals God, and therefore equals in the eyes of the law. And it can be no other way. So any time that we are exercising judicial or governmental power, we are doing one of two things. We are either compelling you to do something you don't want to do, or preventing you from doing something that you do want to do. Now, there are legitimate places and times to do that, right? So, you know, when you get in your car and drive home, I'm hopeful that you all are going to be following the laws of the road, and you're all going to drive on the right side of the road. And if you don't, there's going to be a nice gentleman with a uniform on and a sidearm who will pull you over to have a conversation about what the law requires of you. Now, why is that? Because if we all decided which side of the road we wanted to drive on, we could not go about our business without endangering each other's lives. So we could say, all right, I understand, maybe you're British and you want to drive on the left side of the road, but we don't do that here. And we can legitimately compel you to drive on the right side of the road because we don't want you endangering others, right? So this is the way that we live together in society in a way that preserves liberties, but allows us to live in a way that we can remain at peace with each other and with the potential for prosperity as we come to each other as equals. And then we work off of that basis on what we can legitimately compel or prevent.
Excellent, thank you very much. I'm going to ask a question on behalf of an audience member. 2A is under fire and under threat a lot in our state. How would you as a Supreme Court Justice protect that right? Is that within your scope to protect? Like, how would a Supreme Court Justice continue to protect our Second Amendment rights?
Well, at first, recognizing that there's a Second Amendment, which some people don't recognize or wish it away, but it's there, right? And United States Supreme Court, and the relatively recent, it's been a few years now, case of Heller, made it quite clear that this is an individual. Just as a little bit of historical background on this right, those who want more gun control, they look at the Second Amendment and they say, well, that's really a collective right. So when it talks about a well-regulated militia, what that means is that your right to keep and bear arms is strictly in relation to being part of a well-regulated militia. And so it's a collective right. If you're in the militia and doing militia things, then you can keep and bear arms. And Justice Scalia, in the Heller decision, went through just an extraordinarily detailed and precise analysis of the historical record. And he says, no. That may have been the impetus for putting the Second Amendment there, but it does not constrain the right. It is an individual right. Okay, now the reason I feel comfortable speaking at length about that issue is because the United States Supreme Court, when it speaks on something, it's authoritative and binding on state court judges. So you go to Article 6 of the United States Constitution, there you will find that it says that the United States Constitution, the laws passed pursuant thereto, and the treaties of the United States are the supreme law of the land. And then the framers, well, they were anticipating state court judges, and they said, no, by the way, state court judges, this means you too. You have to follow this too. So you don't get to disagree with the federal. So any decision that we make on the Second Amendment or the right to keep and bear arms has to be consistent with what the United States Supreme Court has already said about it. Now, going beyond that, I will say that the first opinion that I wrote for the court, so the first majority opinion, was the case Wisconsin-Cary versus the city of Madison. So Madison decided that it wanted to restrict the ability to carry concealed weapons. Well, there's a state statute that says, hey, all of you municipalities, you may not regulate the keeping and bearing of arms more strictly than a state statute. So you have to look at that and say, everything you do on this subject has to be no more strict than that state statute. And state statute provides for concealed carry, except in specific limited instances, right? So it identifies the places where you may not carry. City of Madison says, well, we've decided that you cannot do concealed carry on public buses. And Wisconsin-Cary said, that seems more strict than the state statute that doesn't say anything about not being able to carry it on municipal. So they brought that lawsuit, came to us for resolution, and we said, sure enough, that's more strict. Interesting what Madison's argument was, though. So the statute says that a municipality may not pass an ordinance or a resolution that is more strict than a state statute. And Madison says, aha, we got you. This is neither an ordinance nor a regulation. It's a rule. Really? That's your argument? So I had a little bit of fun with that, in my opinion, because what we're looking for is, when we look at statutes, is their plain meaning. So I went through and described what an ordinance is and what regulation is and what kind of legislative authority that describes. And what we discovered is that between those two terms, that encompasses the entirety of a municipality's legislative authority. So we said, well, it doesn't really matter what you call it. If you're exercising that authority, you are subject to the statute. And they said, no, it just matters what you call it. And I said, okay, look, this is legislation as comedy, with a wily municipality first passing a rule and then an obligation and then a prohibition and the hapless legislature chasing them around, striking those down one after another until one of them runs out of words in the thesaurus or the tires of the chase. But it's just a game to them. The answer was, does ordinance and regulation describe the entirety of a municipality's legislative authority? And because it doesn't matter what you call your legislative act, it's the state. I don't remember where that question started, but I kind of like where it ended, so I don't know.
That was a good one. All right, I know there's going to be some disappointed people, but we are really quickly running out of time, and this young lady's been waiting. So we're going to do one more quick question. I know there's some people that probably want to take some pictures, and then I'm going to make sure you get to Walworth County on time.
Wonderful.
Because that's how I am. So hold on one second.
Thank you. You touched on it a little bit with the Dane County and the result of the Supreme Court and how maybe some of the judges weren't sure how that went with the executive order in Dane County, but I was wondering if you could explain a little bit, and my understanding of the Wisconsin Constitution, this is more specific in regards to places of worship, where basically, we won't be infringed on how or where we worship. Dane County also then shut down our churches, or limited numbers of people, or then told us we had to wear masks or stay 6 feet apart. Like, we kind of felt like we were in this bubble in this county. How did they explain that, or how would they explain that, or how would you maybe explain that in regards to our Constitution?
Yeah, and again, so I'll, just as shorthand, I'll have a reference back to a prior answer about, not being able to answer specific questions, how we resolve them on specific issues. But with that, having said that, one of the things that we noticed was that churches were dealt with more strictly than other places where people gather. And I thought that was instructive and curious. So let's start with this. So just a couple of background principles about how we would approach that kind of a question. So churches have a specifically constitutionally protected space, right? So we, both the First Amendment and Article 1 of our state constitution protect the right to worship. And of course that encompasses all aspects of what it means to worship, including gathering together in church and worshiping corporately. All right, so now the question then becomes, well, are there ever any circumstances in which the state can have something to say about what's happening in that church building? And of course there can be. So it can't be a pretext to do otherwise unlawful things. So for example, there was I can't remember how to pronounce the name of the church, Lukumi Babaluwai, I think, church down in Florida. And they did animal sacrifices as part of their worship services. And the question was, the neighborhood was like, wait a minute, you're running a slaughterhouse in a residential area. And the question is, can you do that? Or can the state? No, there are some things that are outside the bounds. We're looking at actions as opposed to beliefs and the expression of those beliefs. So there are some areas in which you can regulate for the public safety. So there are issues with public slaughterhouses that could affect public safety. Additionally, United States Supreme Court in the Unemployment Division versus Smith case said, well, can you use your faith as a reason to use drugs that are otherwise prohibited? And the United States Supreme Court says, well, no, you can't. Similarly, if there is, if the church is on fire and creating a danger to any who might be in there, if people want to go into the church, it's legitimate for the firemen to stand there and say, no, you can't go in. That is destructive. However, when you look at differential treatment, that's where that really catches our eye on the court. Because when there's differential treatment, when similar kinds of things are being done, but you're treating those who are exercising their faith more harshly than those who are not, that tells us that there may be an illegitimate reason for what the government is trying to accomplish. And so when we look at the shutdown orders and we see areas where people can gather together in larger numbers than you can in church, or more frequently, or with less spacing, or whatever it might be, when there's that differential treatment, that's a strong suggestion that there's unconstitutional impetus behind that regulation. And so we'll look at those a little bit more closely. So what we're looking at doing is protecting the rights provided by the Constitution, but not allowing anyone to use those as a pretext to do something that would otherwise be illegal. Does that about get it? All right. Or at least close enough. And again, no ultimate answer in there, because of course I can't say that before a case would reach the court for resolution. All right, well, I think that's probably it. Can I tell you, thank you so much for coming out this afternoon. It's been a pleasure spending this time with you. Thank you.